Welcome back, future lawyers. This is part 2 of the general principles in obligations and contracts. Let's pick up where we left off and also let's begin right away. First, let us distinguish between culpa contractual and culpa aquiliana. And first distinction is culpa contractual. Negligence is merely incidental in the performance of an obligation, while negligence is direct, substantive, and independent in culpa aquiliana. There is always pre-existing contract relation in culpa contractual, where they may or may not be a pre-existing contractual obligation in culpa aquiliana. The source of obligation of the defendant to pay damages is the breach or non-fulfillment of the contract in culpa contractual, while the source of obligation is the defendant's negligence itself in culpa aquiliana. Lastly, the proof of existence of the contract and of its breach or non-fulfillment is sufficient prima facie to warrant recovery in culpa contractual. Meanwhile, the negligence of the defendant must be proven in culpa aquiliana. The following are the duties of the debtor in obligations to give a specific or determinate thing. 1. To preserve or take care of the thing due with the proper diligence of a good father of a family. 2. To deliver the thing itself. 3. To deliver the fruits of the thing. 4. To deliver its accessions and accessories, and 5. To pay damages in case of breach. Whereas the corresponding rights of the creditor in obligations to give a specific or determinate thing are as follows. 1. To compel delivery. 2. To the fruits from the time the obligation to deliver arises. 3. To the accessions and accessories even if not mentioned. 4. Not to be compelled to receive a different one, although of the same value as or more valuable than the value which is due. And 5. To recover damages in case of breach, exclusive or in addition to specific performance. Now let's discuss obligations with a period. Under Article 1193, the Civil Code provides obligations for whose fulfillment a day certain has been fixed shall be demandable only when that day comes. Obligations with a resolutory period take effect at once but terminate upon arrival of the day certain. A day certain is understood to be that which must necessarily come, although it may not be known when. If the uncertainty consists in whether the day will come or not, the obligation is conditional, and it shall be regulated by the rules of the preceding section. Under Article 1196, whenever in an obligation a period is designated, it is presumed to have been established for the benefit of both the creditor and the debtor, unless from the tenor of the same or other circumstances it should appear that the period has been established in favor of one or of the other. Once the court has fixed the period, then it will become part of the covenant of the contracting parties. Article 1197. If the obligation does not fix a period, but from the nature and the circumstances it can be inferred that a period was intended, the courts may fix the duration thereof. The courts shall fix also the duration of the period when it depends upon the will of the debtor. In every case, the courts shall determine such period as may be under the circumstances have been probably contemplated by the parties. Once fixed by the courts, the period cannot be changed by them. Article 1180. When the debtor binds himself to pay, when his means permit him to do so, the obligation shall be deemed to be one with a period subject to the provisions of Article 1197. To summarize, courts may fix the period of an obligation when 1. The obligation does not fix a period, but from its nature and the circumstances, it can be inferred that a period was intended. And 2. The obligation depends upon the will of the debtor. Article 1179. Every obligation whose performance does not depend upon a future or uncertain event or upon a past event unknown to the parties is demandable at once. Every obligation which contains a resolutory condition shall also be demandable without prejudice to the effects of the happening of that event. There are two kinds of obligations. First is a pure obligation. It is one whose effectivity or extinguishment does not depend upon the fulfillment or non-fulfillment of a condition or upon the expiration of a term or a period, and which as a consequence is characterized by the quality of immediate demandability. The second kind of obligation is a conditional obligation. In conditional obligations, the acquisition of rights as well as the extinguishment or loss of those already acquired shall depend upon the happening of the event which constitutes the condition. Now, what is a condition? A condition is a future and uncertain event upon which an obligation is made to depend. Moving on, under Article 1182, when the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon the chance or upon the will of a third person, the obligation shall take effect in conformity with the provisions of this code. Conditions may be classified as suspensive or resolutory. Suspensive obligation shall only be effective upon the fulfillment of the condition. The obligee acquires a mere hope or expectancy protected by law upon the constitution of the obligation. Suspensive condition is deemed fulfilled when 1. The obligor intends to prevent the obligee from complying with the condition. 2. The obligor actually prevents the obligee from complying with the condition. The two requisites must concur. Mere intention of the debtor to prevent the happening of the condition or to place ineffective obstacles to its compliance without actually preventing the fulfillment is insufficient. International Hotel Corporation versus Joaquin. In essence, conditions are traditionally classified as suspensive when the fulfillment of the condition results in the acquisition of rights arising out of the obligation. If the suspensive condition is fulfilled, the obligation arises or becomes effective. If it is not fulfilled, no juridical relation is created. In essence, a suspensive condition suspends the rights and obligations under a contract until the condition is fulfilled. Once the condition is fulfilled, the contract is deemed to have been in force. However, if the suspensive condition is not fulfilled, then no binding contract between the parties come into existence. Another kind of condition is the resolutory condition, wherein the obligation is demandable at once without prejudice to the effects of the happening of the event. Upon the happening of the resolutory condition, the rules of Article 1189 shall be applied to the party who is bound to return. In other words, there is no suspension of the terms of the contract. The rights and obligations come into existence immediately upon agreement between the parties or upon the meeting of the minds. Under Article 1189, when the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. 1. If the thing is lost without the fault of the debtor, the obligation shall be extinguished. 2. If the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes, or it goes out of commerce, or disappears in such a way that its existence is unknown, or it cannot be recovered. 3. When the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. 4. If it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment with indemnity for damages in either case. 5. If the thing is improved by its nature or by time, the improvement shall inure to the benefit of the creditor. And 6. If it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. Another kind of condition is impossible conditions. Article 1183. Impossible conditions, those contrary to good customs or public policy, and those prohibited by law shall annul the obligation which depends upon them. The part of a divisible obligation which is not affected by such condition shall be valid. Note that divisible obligations are those which have as their object a prestation which is susceptible of partial performance without the essence of the obligation being changed. We shall discuss about divisible obligation in the next video. The kinds of condition as to cause. Potestative, the fulfillment of the condition depends on the sole act or decision of a party. In other words, it depends upon the will of a party to the obligation. Casual, when the fulfillment of the condition depends upon chance or upon the will of a third person. Mixed, the fulfillment of the condition depends partly upon the will of a party to the contract and partly upon chance and or will of a third person. If the condition is potestative in the sense that its fulfillment depends exclusively upon the will of the debtor, the conditional obligation shall be void. Article 1182. If the condition is potestative in the sense that its fulfillment depends exclusively upon the will of the creditor, the conditional obligation shall be valid. This is so because the provision of the first sentence of Article 1182 extends only to conditions which are potestative to the obligor or debtor. Besides, the creditor is naturally interested in the fulfillment of the condition, since it is only by such fulfillment that the obligation arises or becomes effective. If the condition is casual in the sense that its fulfillment depends upon chance and or upon the will of a third person, the obligation shall be valid. If the condition is mixed in the sense that its fulfillment depends partly upon the will of the party to the obligation and partly upon chance and or the will of a third person, the obligation shall be valid. This is the end of part 2 for obligations and contracts. Thank you for watching.